His ability to understand complex technologies and appreciate evolving legal trends provide the skills needed to synthesize and design patent protection strategies that are practical and which include the foresight to stand the test of time. So please welcome Don Daley.
Thanks, Derek. And I'd also like to thank the IIPLA. For those of you that it's your first time to participate in this conference, I want to let you know that it's a great opportunity for all of us to speak and profess our expertise and also to get to know each other. So I hope to meet all of you during this time. This is my third conference. I spoke in Dubai and spoke in London, and I definitely encourage people to come back and do it again. Like I said, it's a great forum. So as Derek said, I've been practicing for about 30 years now. Actually, my anniversary comes up July 5th. I started at the Patent Office for a couple years in the digital image processing area. And over 30 years, I've dealt with various different problems with my clients. And I think one of the we'll say a great philosopher in the United States, well, maybe not so much, but a great boxer in the United States always said, he said, everyone has a great strategy until you get hit. And this was Mike Tyson. So literally, people would come into the boxing ring with their great strategy against Tyson, and first time you get hit, big problem. So in patents, you typically have similar strategies. You want to make sure that you prepare yourself as best that you can so that when somebody accuses you of infringement, when you take that first hit, you know what to do. And that's what I'm going to talk a little bit about today, what to do beforehand. So when you take that first hit, you're better prepared. So what we're going to talk about today is dealing with patents of others, somebody that potentially accuses you of infringement of their patent. What can you do and what do you need to do in view of recent changes in the United States? And we're going to talk about, I like sports analogies, so we're going to talk about using both your defense and your offense to help you with regard to these potential accusations by others. Oh, sorry, I have my own thing here. Okay, so thinking about sports, we want to think about a good soccer team. If you have maybe a weak offense, you protect that by utilizing your defense. Maybe you have a good offensive team and you want to utilize your defense to help you out. I think in patents it's very important when dealing with your competitors to think about both your offensive strategy, what patents you're using, and how you can use those patents to build a wall, as Gaye explained, to keep your competitors out. And also the more recent importance of utilizing things like U.S. opinions of counsel to help mitigate, at least, potential infringement damages when accused of infringement by others. So for your defensive strategies, well, when somebody does accuse you of infringement, you have to think about your potential risk. What is your exposure, especially in the United States? The U.S. is a big market. And potential risk of injunction. But aside from that, what I want to talk to you about today is now willful infringement, where you can lose an enhanced amount of damages. So say somebody can prove $10 million worth of damages, you're potentially at risk of $30 million worth of damages in the United States if you're accused of willful infringement. So recently, a case came out in the United States, Supreme Court case, and that decision really made it much easier for people to prove willful infringement. So we're going to help you to try to get better prepared if you are accused. We'll talk about timely opinions of counsel, and timely is also very important. And then we're going to talk about your offensive strategies. I get asked by people to give opinions of counsel, and one of the first questions I ask them is, what about your own portfolio? Do you have patents that your competitor might infringe? They're accusing you of infringement. Do you have your own patents? And they say, yeah, I think we have some patents, and they probably infringe some of them. Well, don't just assume that your patents are set up so that somebody may or may not infringe them. You want to try to utilize various techniques in the U.S. that allow you to continue to broaden your claims and protect your inventions even after your initial filing. To build that wall to keep those competitors out. So refining your own patent portfolio is going to be kind of part 2 of this discussion. All right, first we'll talk about defensive strategies and really give you a little background as to why you need to even worry about this. So we'll talk about 3 things. 1, enhanced damages, what are they? case law in the U.S. over the past 10 years, in re Seagate technology has kind of ruled the world as far as whether you need to get opinions of counsel and how easy or not so easy it's been to prove willful infringement. We'll talk about the new decision at the Supreme Court. These are kind of the Federal Circuit decisions beforehand that led to that new Supreme Court decision that changed what you need to do, and now the importance of legal opinions again in the United States. Kind of the tide has changed a little bit over the last 10 years, which tends to happen a lot in patent law, that's for sure. So what are enhanced damages? Well, Section 284 of our statute provides that if willful infringement is found in egregious cases, not every case, that's for sure, but it's a potential risk that you have to think about regarding your potential exposure, and that is up to 3 times or treble damages. And this is kind of a punitive component, a punishment for ignoring somebody else's patent rights. And therefore, again, it's termed more enhancement of the actual damages that are able to be obtained. And lastly, we'll talk about legal opinions of counsel, basically establishing a pre-litigation good faith defense. You got accused of infringement, you went to an attorney, they were able to establish a solid non-infringement position or a solid invalidity position, and therefore you felt like you really did not infringe somebody else's patent. Later on in court, if it's proven that you did, you will just be at risk for regular damages that happened during the course of potential infringement of that patent, and you won't be subject to enhancement of damages. And that's really the big risk that we're trying to prevent. So why do we have to talk about this today? Well, in the past, 2007 to be exact, when sort of our practice changed a little bit, in re Seagate came out. And in Seagate, there was a standard established by the Federal Circuit which made it fairly easy to defend against claims of willful infringement. There was a 2-part test in Seagate. Part 1 was an objective recklessness test, and Part 2 was a subjective test. So subjective, you'd think, okay, well, if somebody took a look at somebody's patent, they knew that they infringed, they continued to infringe, complete disregard, maybe they copied somebody else's product, you'd think this subjective aspect would be important in deciding whether or not willful infringement occurred. But that wasn't the case under the Seagate test. Under the Seagate test, if you could prove that you were not objectively reckless, that you had some even fairly reasonable defense, even if you established it later on by the time you got to court, long after you were accused of infringement, if you had some position where you had some type of invalidity position or some type of non-infringement argument, anything that met this very, very low threshold, then they couldn't even examine the subjective part. Even if you copied somebody else's product, you never reached the subjective prong. So over the last 10 years, it's been fairly easy to avoid claims of willful infringement just by passing this first objective recklessness standard. Well, now things have changed. So what happened? Well, this is based on 2 cases, and I'll just briefly go through it, but I do want to highlight a couple things. One was Halo versus Pulse. And just to show you how bad some of these situations were, the jury found that Pulse directly infringed 3 patents and found that it was highly probable that there was willful infringement. But the judge said, no, can't really look at all these subjective aspects. We need to focus only on the objective component. And as long as they had some reasonable defense, even though it wasn't even close, the judge said, no, we can't find willful infringement. That's just the way the law is with Seagate. And the Federal Circuit said, yes, you're right. We can't find willful infringement in this case. So the second companion case was Stryker. And in Stryker, it was even worse. The jury found that Stryker did willfully infringe the patent, and they quoted testimony that Zimmer infringed Stryker's patents, that Zimmer all but instructed its design team to copy Stryker's products. And this was part of the finding of willful infringement. But when they got to the Federal Circuit affirmed the validity and non-infringement or infringement decisions, but they said, no, sorry, we can't reach this subjective prong. We can't look to the fact that they copied somebody else's product because it's only an objective assessment that we have to reach. As long as there's some small way, some semi-reasonable defense even, we're not going to get to the point of looking at copying of somebody else's product. So you can see we were at a pretty extreme case in the US. We were at a situation where it was very difficult for patentees to prove willful infringement. And just before this case, our firm, Harness-Dickey and Pierce, was part of another decision at the Supreme Court where all of a sudden it made it more difficult for patentees because it made it easier if somebody accused you of infringement and it was a fairly frivolous type of claim that you could actually get attorney's fees from this particular patentee. And when we look at this case, you'll see that the two cases are very, very similar. Now it makes it, in one sense, on a frivolous or not very strong situation of infringement, if somebody continues to sue you for patents, you can actually get attorney's fees back from them. It's much easier to do that now, and it's a totality of the circumstances test like we'll talk about here. And on the flip side, though, it's now going to be much different for the patentees to be able to prove willful infringement, much, much easier than it was before. So, this new test is the totality of the circumstances, and really the Supreme Court in the United States tends to give kind of vague tests. Again, having a totality of the circumstances really just means we can look at the subjective and the objective components when deciding whether or not somebody willfully infringed somebody else's patent. So this is our new enhanced damages test, and you look at the particular circumstances of each case, but really what they're trying to do is to say to the district court, look, you have discretion. You hear all the testimony, you hear all the input, you get all the facts. You can decide, was this a case, looking at all the subjective and objective circumstances, was this a case of willful infringement? So, more power to the district courts means essentially it's now much easier to prove willful infringement. Again, the Supreme Court cautioned that it should be limited to egregious cases. We can't just have willful infringement in every case. Second part, really, really important part of this decision is how to prove it. In the US, we have essentially three standards. There's clear and convincing, there's preponderance of the evidence, which is what we have now, more likely than not, 51%. There's clear and convincing, which is a much more difficult standard, 75%. And then there's beyond a reasonable doubt, which is 99-100% for criminal cases. Well, we used to be under a situation of clear and convincing. Now we're under a situation of preponderance of the evidence. Again, much easier for somebody to prove willful infringement. So now we've got a totality of the circumstances test, that's easier. The standard, preponderance of the evidence, is easier. And the third part that makes it even more important to pay attention to this is the standard. The standard is abuse of discretion for review. So now the district court makes a decision, they hold willful infringement, it goes up to the next level, and instead of a de novo standard, where the Federal Circuit reviewed all the facts on their own and could change the opinion of the district court, now they have to say, well, did the district court abuse this discretion that they had? Again, much more difficult to overturn. So much easier to prove willful infringement, much more difficult to overturn. So all of a sudden, everybody has to be really, really careful in the United States about potential willful infringement and potential tripling of the damages that's found and potential tripling of the exposure that you have in the States. So here's just a quick summary slide. The good in green, only limited to egregious cases, but the bad, totality of the circumstances, not the bad, but just the different. Totality of the circumstances, preponderance of the evidence, and this abuse of discretion standard. So what can we do to protect ourselves? Well, we have to go back and think about what we used to do, and that's get opinions of counsel from the United States. Again, we get to a situation where we're looking at, and this is another important part, the defendant's state of mind at the time of the infringement is relevant. So what the court cautioned is people getting opinions of counsel after litigation has already started. it's kind of too late at that point. So you have to prepare yourself and you examine, obviously, you get accused of infringement, companies get accused of infringement all the time. You don't want to go running to your U.S. counsel right away, but you want to have kind of a triage system of what you look at first and what becomes an imminent threat, and okay, this is a possibility of a suit, we better get ourselves an opinion of counsel to protect ourselves. And we really, depends again on the strength of your position. Okay, so I don't think we have to go through this too much. Okay, so I would say, I think we touched on, here we go. So why are legal opinions important? I can give you a couple other reasons. One is this threat of willful infringement and this potential tripling of damages, but also opinions of counsel give you other things, and one is you can assess your the patent validity strength and create other positions. Maybe it's a strong negotiating position. That's happened to me many times. We've done prior art searches. We go to the table. We negotiate with opposing counsel. We have good prior art. Sometimes a very reasonable license is presented, and sometimes they just go away. And now with the threat of IPR in the United States, the risk of patent invalidity is a lot stronger than it used to be. So again, getting your opinions of counsel and presenting strong invalidity positions could be a deterrent to somebody accusing you of infringement. And the second part is on the non-infringement side. Very important in the United States that you look at the entire prosecution. What happened during prosecution? What claims were amended? Maybe we can establish some positions where we either provide a very solid non-infringement position, or maybe we create some type of a design around opportunity. But again, looking at the claim scope and the totality of it and having somebody that really understands U.S. practice is important. So that's number one. You want to think about your defensive strategies, but more importantly, and this is a little bit of a follow-up from what I discussed last year, but again, I can't reiterate it enough, and that's to utilize your offensive patent portfolio. Guy mentioned one of the important things is to continuously examine your portfolio and what's important and the time of it. I can't emphasize that part enough, because you file in a foreign country, year later or so, you file in the U.S., maybe a long time later, you end up filing a PCT application. Maybe it takes a year or 2 years or 3 years to get your first office action, depending on your technology. Reevaluate your portfolio at that time. Is this still an important patent, and is this something that you really have to think about? Generally, that strategy is important. We're also going to talk about specifically what happens when a company accuses you of infringement of their patent. Now it's really time to look at your offensive portfolio. So getting a patent is just one part of what we do. I guess the most important part is how do we get more valuable patents. And thinking about with regard to your competitors, for example, you want to look at and obviously monitor your competitors' products, trends, and your particular patent portfolio. If somebody accuses you of infringement of their patent, you want to at least have some type of leverage on your side. You don't want to say, oh, I have this portfolio and I'm sure they probably infringed something of ours. No, you want to take a look at it, you want to draft your claims, and you want to make sure that you capture your competitors. Even if they have a dominant patent and you just have maybe improvement patents, well, those improvement patents could be really, really important. If I have a patent on a television and then somebody else has the patent on the remote control, this day and age, I'm not going to be able to sell my television without the remote control. So it's important even if you have the dominant patent and the secondary patent. Okay, so what are the three things that we can utilize? One is in the U.S., you can always broaden your claims. So throughout prosecution, even if you file with narrow claims and you get narrow claims patented, as we continue, you can either amend your claims during prosecution and broaden them out, if that's what you're entitled to, based on the prior art and the prior art that's found. You can file them broader in continuations, and we can file them broader even after they've patented during the reissue process. So realize that the U.S. is a little bit different than other countries. And even if you file in a narrow way and you realize, oh no, my claims are a little bit too narrow, I shouldn't have filed that narrowly. Or I look at my competitors and their products and the people that are accusing me of infringement and you say, oh geez, my claims when originally drafted were a little too narrow. What can I do? Well, you can broaden them out. So, broadening of claims at any time is permitted. That's our main tool. This is the extent of my graphics. You can see that I'm more of a content guy. Beautiful presentations by my other members, so I let them kind of handle that part. This is the extent of my graphics right here. You get the screwdriver, most important tool, you use it all the time. That's the broadening aspect. Think about that. 2, utilizing and understanding continuation practice. That's the saw. We want to carve up our applications as much as possible. Utilize that practice. I think continuations in the US is the most underutilized form of our patent prosecution. Very low incremental cost for continuation. We'll talk about that. And the last part is reissue practice. The clamp, something we don't use all the time, but a very important tool when we need to use it. So, broaden claims at any time. In this situation, we want to understand our competitors' products. As a U.S. patent attorney, I know patent law. And I know technology. I can understand other people's patents, and I can figure out what the differences are. But I don't necessarily know your products unless you give me that information. I don't necessarily know information about your competitors' products unless you give me that information. So as a U.S. patent attorney, somebody working with a U.S. attorney, the most valuable thing you can do is provide this type of information. That way you're going to get valuable patents. You're going to get patents that you're going to be able to monetize, that people were talking about here. And for this purpose, you're going to be able to get patents that are hopefully going to help you in negotiation against somebody that's serious against you regarding patent infringement. So, look at your product. Look at your portfolio. Number 1, what is pending in that product area? That's, okay, you're accused of infringement in, we'll say, a memory storage area. So you're going to take a look at your memory storage patents and see what you have. But if the company that accuses you has technology in other areas, don't forget these other areas that are there too. They can still provide you with some leverage in negotiation. So take a look at whatever your competitor makes and the patent portfolio that you already have. Look and examine your allowable subject matter that you might have. Maybe in certain situations you have A, B, C, D in your claim, but you don't need A, B, C, D. Maybe the allowable part is element B. Maybe you can draft a claim as broad as just A and B. So think about what with regard to your existing portfolio, what's your allowable subject matter. Don't assume that you have a portfolio and they must infringe something. I'm tired of getting that information from my clients. I say let's actively take a look at our portfolio and make sure that somebody infringes, because we can continue to broaden our claims. So eliminate or broaden non-critical elements. Take a look at anything else that should be adjusted in your claim. Do you have some extraneous elements in your claim that your competitor doesn't have? And make sure that now the competitor's products infringe your claims. 2, continuation. So we're going through prosecution. We find some allowable subject matter. We decide we want to broaden our claims. Great. But maybe the examiner is not ready to allow this yet. He's not sure. We're still in kind of a negotiation. And one of the things I want to say with regard to the USPTO that I found over the last 5 or so years is the negotiation process is much better. We've never wanted to have an adversarial process with the United States, but now we see more examiners reaching out to us and talking to us more about what is reasonable in this particular situation. But again, what you come up with on your first deal might not be what you're ultimately should be entitled to. So maybe you get a patent, and then you take a look at the products, your competitors' products, etc., and you say, well, maybe we can get an even broader patent. Well, you can do that through the continuation practice. As long as you file something before your patent application issues, maybe you just file it by canceling a couple claims that you had originally. And then you follow it up with some type of preliminary amendment that sort of sets you up with regard to your competitors' products. So that's what we want to think about. Reviewing your own products to build your wall, your fence around your intellectual property, and then reviewing your competitors' products for any changes that might happen. If you can keep continuations pending in important technologies, you always have the opportunity to sort of reevaluate this process. So again, one of the things I wanted to talk about here is the very low incremental cost in a continuation. And say you're filing, and my clients are in Japan or Germany, and they file in their native language. A year later, they file in the US, they translate to English, and they have to pay the fees for filing in the US. They prosecute. I have to learn what the application's about. The examiner has to learn what the application's about. More money is spent, and so you have a cost, say, way up here for your first patent application, and you were able to get reasonable claims. But if you file a continuation application, that might only cost you a little bit more in the incremental cost. And potentially you get a patent that's much more valuable than the patent that you had the first time. So thinking about continuations, and is this an important technology, and is this worth that incremental cost, that low incremental cost? I'm telling you, it's the most underutilized tool that we have in the US. And the fact that you can continuously broaden your claims with regard to continuations, again, even makes it much more valuable. So really, really think about using continuations. I have one short example. I love this case. It came out in way back when, 89, 90, something like that. But it was Rico versus Nashua. And in this particular case, Rico had a patent. And they filed their application, and as it's going along, they actually filed a continuation application. Now, in the past, those continuations were secret. We called them kind of submarine applications because, as you can see, this continuation kind of submerges and eventually reaches the surface again. So they were even more valuable back then. Now they're public information, but still, if I'm in negotiations with you and you have a patent and you're accusing me of infringement, and you also have a continuation that's pending, where claims might change, all of a sudden it becomes much more difficult to circumvent your patent portfolio. So what happens in this particular case is the competitor, which was Nashua, it was toner cartridges, they took a look at this first patent that issued from Rico, and they were paying licenses on this first patent. And then after a while they said, well, we don't want to pay license fees anymore. So we're going to redesign our product. And Rico said, okay, let's see your redesign to see if it actually infringes. So Nashua showed Rico the redesign of the product. What they didn't know is Rico had a continuation application that was pending. Now that they had Nashua's product, they changed the claims in the continuation, broadened them out, and Nashua became an infringer of this second patent when it issued. So kind of lesson to be learned, if you're negotiating with somebody, and they have a patent, number one, find out if there's any continuations pending. That's all publicly available through the PAIR system in the US. And definitely keep that in mind. If they don't, it becomes a much easier negotiation. But two is keep your own continuations pending. So that if you have an important patent, you can go back, broaden your claims, and capture your competitors as well to give you a much stronger negotiating position. And the last step will be the reissue practice. In the US, we can file a broadening reissue within 2 years of patent issuance. And again, we can utilize the reissue practice to capture our competitors. Now, continuations, we'll see, are much better than reissue, but reissue is still good. One, intervening rights will apply with reissue. Very complicated situation, but basically, if somebody's infringing not infringing your initial patent and later they infringe your reissue patent, they can continue manufacturing based on your original patent, and you're only able to get an incremental difference, some increase in damages. So it's a damage minimizing factor. For continuations, no intervening rights applies. You will be able to get damages on the whole thing, not just the incremental change. So continuations are better, but still reissues can help you a lot. You can't include recapture of subject matter that you gave up during prosecution. So if you had claims and you got them allowed right away, no prosecution history took place, no problem. You can broaden your claims out and reissue, capture your infringer. But if you added a limitation during prosecution, then you can't later go back and remove that limitation to try to broaden your claims out. So the recapture rule applies. With continuations, not an issue. If you amended your claims to make it A, B, C, D, you added element D, and you want to remove element D from a continuation, no problem. That's fine. So no intervening rights will apply. Another thing with reissue is one-to-one broadening reissue is filed, again, within 2 years of patent issuance. You can file continuations of those reissues over and over and over again so that you can continue to even further broaden your claims as long as that first broadening reissue is filed. So 2 times, I would say. One, where you're really concerned about your competitors and you look at it's a very hot area for you and you've got some patents that are within 2 years, hey, we may want to broaden them out. Second situation is when you buy a patent. You purchase a patent from somebody else, it covers some of your products and maybe some of your competitors' products. You want to maybe license it. Well, if it's within 2 years, you might want to consider filing a broadened reissue application. Now you can again make sure that it covers your competitors or make sure that you build a better fence using this. We've had this situation occur with some of my clients where they purchase patents and they want to keep their original patent that they purchased, but they also want to get a broadened reissue patent. So the last thing I'm going to talk about is In re Tanaka. 2011 case. Very important case for somebody that buys somebody else's patent. So in Tanaka, we had a situation where 10 original claims, we want to file some broadened claims, 11 to 20, but with Tanaka, they also added a couple other claims, 21 and 22. 21 and 22 were dependent on the original claims, 1 to 10. There was a rejection, which happens a lot in reissue of the broadened claims. The original claims were allowed, but those original claims, if you know, during reissue are at risk, and you could lose them. So in the situation of Tanaka, Tanaka said, oh, well, I'll cancel all my broad claims, and I want to reissue this patent because it's got something new in it, something different. It's got those 2 new claims, 2 new dependent claims, 21 and 22. They're dependent on 1 to 10, but it makes the patent different from what was originally present. And in Tanaka, they said yes. They call that a hedge against invalidity. You're strengthening your invalidity position by adding those 2 dependent claims, and that makes your patent different enough so that the patent office must reissue this patent. So we had a similar situation. My client bought a patent. They wanted to license that patent, and I said, well, okay, you can continue to license it, but we'd like to get it out and keep it safe and go after these broader continuation claims. So we did what Tanaka did before Tanaka actually came out. And we argued with the patent office. We canceled claims 11 to 20. We wanted to reissue the patent. The patent office said, no, can't reissue it, can't reissue it. It's not different enough. And Tanaka came out. And then they said, yep, now we have to do it. So now they have their original patent that they bought out of reissue, and we pursued the broadened claims in reissue. We got them 3 or 4 other broad patents, and they were very, very happy with the portfolio. So again, think about broadening of claims, reissue applications, continuation applications. Okay, that's about all I have. I guess at this point, we'll open the floor up to some questions.
Okay, I'd like to we have a little bit of amount of time left. I have a couple questions myself, but before I ask mine, I want to find out, does anyone in the room have a question for any of the panelists? Yes, sir.
Yeah. The question is for Nicholas. Your indemnification, does that include the attorney costs that your customers are making as well? That's the first part of the question. And the second part is, I don't know if you can disclose that number, but how much did Microsoft pay out in indemnification to its customers under this program?
I'm sorry, can you repeat both questions?
Yes, the first one is, does your indemnification that you're providing cover the attorney costs that your client has to make when he's being accused of infringing?
Yeah, so usually when you have a indemnification, the supplier takes control of the defense. So when you do that, then the attorney costs are really your own, and then it depends on the actual terms that you agree.
But does Microsoft cover those? Your indemnity, typically the indemnity covers the costs that are being awarded in court, the damages awarded, and depending on the indemnity clauses, you exclude or include reasonable attorney fees, those kind of things.
As I said, if Microsoft takes control of the defense, then the attorney's costs of Microsoft are covered by Microsoft.
And the second, can you disclose how much you paid out already under this program to your clients?
Yeah, so it's uncapped, meaning there is no monetary limitation. If the final award is $100 million, we would pay $100 million.
But did you pay already out anything?
Well, there was one example where Microsoft stepped in for a patent infringement against one of the computer manufacturer who was incorporating Windows, and I think it was Lucent at the time versus Microsoft, where there was a jury verdict in a range of $1 billion or over. And so that was actually a liability for Microsoft, and that went into appeal, etc. But that's a well-known case where there was a public known amount which was awarded in the context of indemnification.
Any other questions?
Okay, a similar question. A similar question here. So in your slide, you mentioned that the indemnification is uncapped.
Yes, no
So-
monetary limitation.
Yeah, I would say in most commercial practice, people want to cap the indemnification. For example, Microsoft may want to cap the indemnification as the subscription fee for your cloud services, things like that. So I'm just wondering, what is the rationale?
So
for
it depends
Microsoft
about
to
the
uncap?
financial strength of the supplier
Okay.
and the amount of risk the supplier is willing to take to protect its customers. I would say it depends on every supplier is in a different situation. If a particular company is dealing with a supplier of a smaller supplier who is willing to take an uncapped liability, maybe that doesn't make a lot of sense. If it's a small company who accepts an uncapped liability, it's not going to be worth a lot because they won't be able to pay a lot. So in that case, it makes sense to cap for a smaller company. For a company like Microsoft, when you have a contract with uncapped indemnification, certainly that has more value.
I think just one more question, and I think we're going to be at the end of our time in the back.
Thank you. This is a question for Don. I was kind of intrigued that, I guess in broadening reissues, you're allowed to file continuations. That's something that I wasn't aware of. Can you do the same with narrowing reissues?
Yeah, you can always file continuations of your reissue application. So you get a first patent, we'll say, as far as getting the reissue granted, you can file a continuation of that. Now, the difference would be in a broadening reissue, you file it within 2 years. It's got some broadening aspect. You can file even broader reissues as you go on. In a narrowing reissue situation, clearly you wouldn't be able to broaden the claims during your continuation filings.
So if you're past the broadening reissue phase, so if you file a narrowing reissue, and then if you want to file continuations off of it, the subject matter that you can pursue from those continuations will be, by definition, have to be narrower than the original patent granted.
Correct,
Okay.
correct.
Okay.
Yes, yeah, I'm sorry, I didn't mean to confuse anybody. It's the broadening reissue that allows you to file broader continuations. A regular reissue, you would file continuations, but they would have to be narrowing continuations.
Thank you very much.
Thank you to our speakers for your healthy contribution today. Before you go, I want to present you all with a memento.